who are joining us online. And we're going to start this morning with the Honourable Hekia Parata. Good morning. Thank you for joining us. We've got you for 10 minutes this morning, so I'll hand over straight to you.
Kia ora. Tēnā koe, Mr. Chair. Tēnā koutou, ngā mema pāremata, e whiriwhiri ana tēnei kaupapa pāna ki te tiriti, o tira kia tātou katoa ngā mihi nui. I want to acknowledge the committee for the seriousness with which you are tackling this challenge and the amount of work that you have had to and will have to get through. And I want to acknowledge the committee's staff and officials who've lent into the challenge with their service and support. I also want to acknowledge all the New Zealanders who've marched and submitted when they really have home life demands that they would prefer to be focused on. And I'm pleased to take the committee's guidance that I don't need to rehearse my written submission and can be taken as read. Thank you. I oppose this bill and I recommend that the Select Committee report it back to the House by substantial majority that the bill is irretrievably flawed and should waste no further resources of the House nor our nation's tolerance. It should be voted down without further debate. And instead, I recommend that our focus should be on establishing the conditions for Te Tiriti o Waitangi to be honoured in modern and forward-looking ways as the original signatories anticipated for all of us. I'm going to make 2 points, a live example and a couple of observations, and then answer any questions that you might be minded to ask. The first is the persistent conflation of the collective rights held by iwi hapu and tangata whenua and practice and related only to their specific rohe, and the individual citizenship rights that Māori have as New Zealanders, which they are free to exercise anywhere they choose to make their home in our country. It is this persistent failure of public policy and public management that creates many of the misunderstandings that New Zealanders have. And 3 examples spring to mind that I hope will speak to this problem. One was the corporatisation state-owned enterprise policy, which ended in a Court of Appeal judgment, and then a Treaty of Waitangi State Enterprises Act that protected the right of land claims while allowing the government to go about its macro policy. A second was the foreshore and seabed, which said that it belonged to Māori, and those beaches on the Tairāwhiti were considered by Ngāti Porou to belong to them, as did Ngāpuhi and Northland, and I was going to say Tūhoe, but they're landlocked. And so they were never a citizen's right in the sense of the foreshore and seabed policy. And finally, 3 rivers, which recognised that there is iwi mana in particular rohe, and they were being invited to nominate boards to manage the water right. It was not Māori who were being given that opportunity. And so those have seen marches up and down our country as well, and that will continue unless we really tackle this issue of the definition of rights and the right holders and the circumstances in which those can be exercised, which, by the way, we do for every other public policy and public management issue. So the conflation of Māori and tangata, tangata whenua, needs to be understood and distinguished. Now, that leads me to my second point, and that is that they are held by the same person at the same time, but we are multiple rights holders, all of us in different ways, and it seems to me that we have the wit and the brain to be able to make these distinctions. In either of those concurrent identities, Māori do not always enjoy equality equally, not because the principle isn't already well established in our very active democracy, but because, as with this bill, there is an assumption that the practice of equality must look the same. This bill will not address that inequality, it perpetuates it. The example I want to offer up to you is Te Ara Tipuna. It's a project I've been leading and developing in Tairāwhiti on the east coast, a 500-kilometre walk around the coast from Gisborne to Opotiki. It will traverse 4 iwi rohe and 3 territorial local authorities, and the exhaustion you see on my face is not trepidation about this committee, but for the first time going through a resource consent, and it is an arduous process. Te Ara Tipuna is likely the biggest whenua Māori project since Sir Apira Ngata's land development scheme in the 1920s. It traverses 444 land parcels, 85% of which are multiply owned whenua blocks. Now, those owners do not enjoy the exercise of their property right in the same way as any other property rights holder enjoys theirs. Because of chronic under-resourcing of the institutions of the state that are charged with carrying out those responsibilities, that is the Māori Land Court under the jurisdiction of Te Ture Whenua Māori 1993, the backlog in the registry of succession orders means that the possibility of having governance entities is remote. And that means that they have the semblance of a property right, but none of the conditions in which they can exercise it. They can't go to a bank to get borrowings. They can't make decisions about whether to sign an easement. And to demonstrate how unequal the treatment is of a real estate right, this is the flow chart of how to get an easement, right? On the right here, there are 5 steps for general land. On the left, there are 27 steps for Māori land, under which are checklists of steps that amount to about 100 steps, simply for whenua Māori owners to be able to join the government in its aspiration of economic resilience, economic growth, economic productivity. So Te Ara Tupuna, I welcome you to come up to the coast. I invite your support. Who doesn't want to do a long walk these days? And farmers are more and more saying that farming is becoming the side hustle, as walking and cycling and horse trekking, all 3 modalities we propose to offer up the coast, if we can just get through the resource consent system. I'm going to finish with 2 observations. One of the oft-repeated statements or inferences that have characterised the discourse around this debate is that where in the world has ancestry been the driver of rights? I find that incredibly ironic, because the authority of this committee and the proposer of this bill rests on a kinship-based ancestry property-owning royal family known in New Zealand as the Crown. Secondly, this idea that collective and individual rights can't or shouldn't be able to be exercised at one and the same time in one and the same person. As I look at you as Member of Parliament and speaking for myself, some of you have come here by the party vote, a collective vote. Others of you have come here by the electoral vote, a personal vote. Some of you have come here by both, because our electoral system provides for the principle of equality to be practiced by there being, as democracy originally was established, one man, one vote. New Zealand led the world and then became retarded along the way in women securing the vote in 1893. But in our overhaul of our system, we recognised our unique democracy, because no democracy is exactly the same. And so every person has 2 votes. One of them is for a collective entity, and one of them is for a personal representation one. If we can do that in our electoral system, why on earth are we concerned about the long-standing right of iwi as collective entities to exercise collective rights and Māori as citizens to exercise personal rights in the same person, in the same country? We do it for every other New Zealander of voting age. Thank you, Mr. Chair. Happy to take questions.
Thank you, Hekia. 2 short, sharp questions. First from Todd Stevenson, then Willie Jackson.
Thank you, and thank you for being here. And I look forward to your support on some of our RMA reform, but that's not for today.
Please come and part hours.
You advised the 4th Labor government around some of the idea of the principles of the treaty.
Yes.
Waitangi. Just curious to understand, in that process, what kind of public consultation was undertaken? Were there public submissions like the process we're undertaking now? And
So what was undertaken there was an election with a government that had a manifesto that said that they were going to pursue a state-owned enterprises policy. In that process, there was a court case, the right of the claimants to go to court and have their claim heard. A judgment was made. The government then set up a working party. I chaired that working party to look at how we might resolve that particular issue. It resulted in an act which allowed people to come forward and give submissions as they are doing here. And then I was tasked with facilitating a group to develop the first set of principles. A number of officials were on those. Those were brought back and became part of the public policy and management responsibility. Those particular principles were not consulted on because they were considered to be a way of managing the government's policy that had been, the government had been elected for. Since then, of course, the courts, the tribunal, and treaty settlements themselves, all in the public arena, have developed and applied those particular principles and more.
Thank you. That's right on time. Thank you, Hekia, for being with us this morning. We appreciate
And I
your
was just
submission.
warming up, Mr. Chair.
I know.
Thank you very
Right.
An
much.
exemption to National Party Minister, it's no exemption.
I'm here as Ngāti Crow.
Oh, sorry.
Thank
I
you.
think you'd have cross-party support for coming back more often, maybe permanently, but who knows? Let's go now to our next submission online. Joining us by Zoom is Julian Batchelor. Julian, good morning. Actually, do we have Julian? Is that just our screen? That's Julian's screen. Oh, good morning, Julian. Welcome to the committee. We've got you for 10 minutes this morning. Hopefully you can hear us clearly. We can see you. So I'll hand over to you to start your submission.
Right, hopefully this works. I'm using PowerPoint this morning, so let's just see that this actually goes. And we can get this sorted. So it's just firing up right now. Oh my goodness, sorry about this. It's,
We can see it.
okay. So this is my oral submission. My name is Julian Batchelor. I represent Stopco Governance. The source document for this bill is the treaty, so my submission will focus on the treaty. The treaty has 5 parts: a preamble, an Article 1, Article 2, Article 3, and an affirmation. In this submission, I draw on facts and quotes from historians, and all quotes are academically referenced. So let's crack into it. I'm using the final English draft of the treaty written by James Busby and in his handwriting. Busby made it clear in his journals that the final English draft of the treaty was written by him in his handwriting, and this was accepted by Hobson. In every respect, this document fits the expected profile of the final English draft of the Treaty of Waitangi. Yet the Treaty in English in the Treaty of Waitangi Act 1975 Schedule 1 is not in the handwriting of James Busby. It's in the handwriting of someone called James Freeman, which means what? The government has the wrong English version of the treaty in the Treaty of Waitangi Act 1975. This explains why there is a big difference between the so-called English and Maori versions. Well, in turn, this has given rise to the need to invent principles to reconcile the differences. There would be no need for so-called principles of the treaty if the true bona fide English final draft of the treaty was in the Treaty of Waitangi Act 1975, because this final English draft and the treaty in Maori are a perfect match. That is to say, if the courts or Maori or MPs or the public want to know with 100% accuracy what the treaty in Maori says, they would only need to read the final English draft. So if you want to fix the issue of treaty principles once and for all, then for God's sake, use the final English draft of the treaty in the Treaty of Waitangi Act 1975. Amend the act. Now to the preamble. What does it say? Well, there is the preamble. I'm not going to read it all, but there is the main point of the preamble. The British said they would set up a government. What exactly did the British agree to in the preamble? The answer is to set up a government in these islands. What kind of government? Answer, a democracy, albeit in seed form. As the infant colony grew, so the reality of democratic government also grew. And democracies have 3 great pillars: singular government, private property, security, equality of citizenship. Importantly, these are the 3 pillars of the treaty. What about Article 1? Well, this is what it says. The chiefs of the Confederation of United Tribes and the other chiefs see to, and I can't quite see because it's something's covering this, but that's what it says. You can see that your part of the screen is covered. Here in Article 1, the chiefs ceded sovereignty completely and forever. What does this mean? It means Maori handed over the complete control of the country to the British forever. Entire means entire, all of it. Not partial control, but entire control. Not the British only ruling over the British, but ruling over all citizens, including all Maori. Again, this is according to the plain reading of the treaty. When Maori talk of establishing a dual government, they are trashing their 1840 elders, breaching the treaty, and ought to be charged with treason, for this is what it is. In 1843, so the question is, how do we know for certain that Maori ceded sovereignty? Well, in 1843, inside the British Parliament, in a 3-day sitting on the question of New Zealand, Lord Stanley reported to his MPs. He said, quote, "It was a historical fact that in 1840, the Crown had asserted sovereignty over New Zealand. Consequently, it was incontrovertible, that's a key word, that all New Zealanders, or that all of New Zealand and all persons inhabiting its territory lay within the dominion of the Crown, unquote. The dictionary defines the word incontrovertible as not open to question, indisputable. Conclusion, anyone who claims Maori did not cede sovereignty is living in denial, which is not just a river in Egypt. Interestingly, the British in 1840 sought out all the chiefs who signed Hei Whakaputanga or the Declaration of Independence 1835, making sure they signed the Treaty of Waitangi. In other words, if the chiefs attained sovereignty in 1835, and that's a fact disputed by historians, they ceded it in the treaty 5 years later. On what authority do we say this? Renowned historian Dr. Matthew Wright says, quote, the Declaration of Independence was accepted by the Colonial Office to the extent that its signatories were sought and collected for the Treaty of Waitangi, which superseded it. So that's pretty clear. There's another quote from Sir Aparana Ngata, the greatest Maori we've ever had. He says that Maori ceded sovereignty. Now on to Article 2. This has two parts. The first sentence says, the Queen of England confirms and guarantees to the chiefs and the tribes and to all the people of New Zealand the possession, that's the key word, of their lands, dwellings and all their property. The key point I want to grasp here is that the English word possession was translated as Tino Rangatiratanga by missionary Henry Williams in 1840. Tino Rangatiratanga does not guarantee Maori ownership of their land in perpetuity. If Maori sold their land, they lost possession of it, the security transferred to the new owner. Imagine how ludicrous it would be if homeowners in New Zealand today could sell their properties, take the cash, spend it, and then demand that the government reissue to them the ownership of the land they just sold. It is also a complete insult to the British and to all New Zealanders that this idea is even being entertained in New Zealand under the flag of Tino Rangatiratanga. Such a demand would not only be laughable, but it's nonsensical. Yet these demands are made by activists today in the name of Tino Rangatiratanga, while MPs meekly nod in agreement, seemingly oblivious to the comical idea that they are agreeing to. I reiterate, if after 1840 Maori chiefs, iwi or hapu, sold their land, they lost possession of it. The historical record shows without doubt that from 1840 onwards, Maori went on to sell 92% of their land. It was not stolen, which is another Mount Everest-sized lie trotted out by activists with regular monotony today. It was sold. So when Te Pāti Māori leader Rawiri Waititi uses the word Rangatiratanga, he uses it as meaning Maori sovereignty. In saying this, Rawiri is delusional. How could Maori cede sovereignty in Article 1 and then take it back in Article 2? Rawiri's ideas are also an absolute insult to the British. I therefore call on the government to affirm David Seymour's original second principle because it synchronizes perfectly with the plain meaning of Sentence 1, Article 2 of the Treaty of Waitangi. That the government would honour all New Zealanders in the chieftainship of their land and all their property. Now to Article 2, the second sentence, which reads just like that. I'm not going to read it all, but the key idea in this sentence is the purchase of land by the British. What did the British promise Maori here to buy Maori land? That is all. Contrary to what activists and the media say today, the chiefs were hungry to sell their land. Acclaimed historian Dr. Bain Atwood reports, quote, there was a growing demand on the part of the natives to dispose of their land without government interference or control. So the twin narratives that we hear today that Maori would never sell their land and that their land was stolen, like I've said, is manifestly untrue. What about Article 3? It reads this, in return for the cession of sovereignty to the Queen, the Maori people of New Zealand shall be protected by the Queen of England and the rights and privileges of British subjects will be granted to them. When Maori in 1840 became British citizens, they automatically became equal before the law with all other citizens. The cry of Maori activists today to claim superior status over all other citizens has no foundation in the treaty. In fact, it's a massive breach of the treaty. Once again, when they say these things, their minds have drifted into what I call treaty fantasy land. Therefore, if politicians want to be faithful to the treaty and not themselves breach the treaty, they have no choice but to make David's third principle law, that all New Zealanders are equal under the law with the same rights and duties. Finally, there is no partnership in the treaty. I hope you notice that in the entire text of the treaty, there is no mention of partnership with Maori, or that the British would only rule over British settlers. Why are these ideas blatantly and obviously missing from the plain reading of the entire treaty? Answer, because those ideas don't exist in the treaty. They're simply not there. They're pure fantasy. They are modern day inventions. It is oxymoronic for a country to be a sovereign and have a partner. Partnership and sovereignty are mutually exclusive concepts. The idea that the treaty is a partnership is the greatest lie to ever come out of the courts. We ought to never accept their judgment when these judgments contradict the plain reading. Judges are not gods. They're just people, and people are fallible and very capable of corruption. I reiterate, there is no mention of partnership in the treaty. Any party or MP who says the treaty is a partnership is not just intellectually lazy, but they're also delusional or deliberately and knowingly lying to the people of New Zealand. Here's my summary. Finally, to the fifth and final part of the treaty, the affirmation. Here, the Maori chiefs signed that they fully understood with what I've just described in this submission. In summary, I support David Seymour's bill because becoming law because his original three principles honour the Treaty of Waitangi in every respect. If the government is sincere with its claim to want to honour the treaty...
Julian, I'm sorry to interrupt. That's the 10 minutes for our time today. So on behalf of the committee, I just want to thank you for your submission and for your presentation.
Thank God.
Okay.
Utter rubbish.
Members, we're going to move on to now next submission from, can we not talk across the table with each other? We're going to move on to our submission from Maui Solomon. Maui's going to join us online.
What a sense. What a presentation was blocking it out.
Yeah, the timer can't appear on the screen when there is a PowerPoint presentation. So members can keep an eye on the clocks as well. They're roughly 10-minute slots, so keep an eye on when they start. Oh, Maui, if you can just turn your camera on. Oh, kia ora, Maui. Thank you for being with us. We've got you for 10 minutes this morning, so I'll invite you to begin your presentation.
Oh, well, kia oranga koutou. Name's Maui Solomon, coming to you live from Rekohu, Chatham Islands. Good to see Willie there. So, look, needless to say, I'm opposed to this bill. And just briefly in response to the previous speaker, look, the short answer is, you know, the chiefs and tribes signed the Māori version of the treaty, not the English version. And the Māori version guarantees them their tino rangatiratanga. And in the English equivalent of that is sovereignty. Now, you know, the thought that, or the statement that these chiefs and these rangatira would voluntarily give up their tino rangatiratanga or their sovereignty to a queen sitting over in London is, to use Mr. Batchelor's words, absolutely delusional. Did not happen. And actually that's been upheld by the Waitangi Tribunal itself. Māori did not cede sovereignty. That's a fiction. Anyway, I'm going to, I know I've got some limited time, so my submission can be taken as read. I've got 40 years experience in sort of Te Treaty Waitangi / Treaty of Waitangi. So I do know a little bit about this, the subject matter. But the first thing I'd like to say about this unprincipled bill is that, contrary to popular belief, and this is a belief that's been promoted by David Seymour himself, this bill is not new. It's the recycled, rehashed, and rejected bill of the previous leader of the ACT Party, Rodney Hyde, almost 20 years ago. Same tune, different dance. And all New Zealand knows how well David Seymour can dance. So the bill was rejected back then, and it should be rejected now. In fact, it should never have even got to the Select Committee. It's been a colossal waste of taxpayers' money in order to serve the ego and the self-political interests of one man. I've listened to the rhetoric promoted by Mr. Seymour to justify Rodney Hyde's previously rejected bill. And just to quote Mr. Seymour, he said he wants to start a public debate. It's all about fairness and equality for all New Zealanders. and we can't let the tribunal and courts decide what the principles are, etc., etc. Now, I could write a book about this, but in the 2 minutes allowed to me left, I don't have, I'll spare you agony of that. I don't have the time. But suffice to say, these statements are baseless and do not withstand even the briefest scrutiny. Firstly, the debate first started in 1835 when the Northern chiefs and tribes very publicly and internationally declared their sovereignty and independence. And this was recognised by King William III. He endorsed the declaration, he endorsed the flag that Māori were trading under. 1835, that was Aotearoa's first international treaty and declaration. And then we come to 1840, when Māori expressly reserved and were guaranteed their sovereignty under Article Tuarua or Te Treaty of Waitangi, the Māori version which they signed, not the English version. And Mr. Batchelor should go and swat up that legal rule of contra preferentum. The drafting is it's construed against the drafter of the treaty. So if the English version got it wrong, that's not the fault of Māori because they knew what they were signing. So yeah, to think that the chiefs and tribes would voluntarily cede their sovereignty 5 years after they'd publicly and internationally declared it is just simply nonsense. The fact of the matter is, Te Treaty Waitangi was legislated into oblivion by this very parliament. And then in 1877, it was declared a simple nullity by Chief Justice Prendergast in the Wiparata case. And this was all done so that Māori land could be taken. And contrary to what Mr. Batchelor says, I don't know who his historians are, but to say that not Māori voluntarily sold 92% of their land is absolutely not true at all. That land was taken at the point of a gun and then later at the point of a pen by legislative fiat. And look, I suggest to Mr. Batchelor and others like him, go and read the hundreds of Waitangi tribunal reports that have been compiled over the last 50 years. And that's where the true history and facts are to be found. And of course, that land was taken to accommodate the influx of settlers from the UK. Now, where was the fairness and equality back then? I asked Mr. Seymour. And if Mr. Seymour seriously expects Māori to have confidence that this House will serve their interests when 184 years of legislative experience suggests otherwise, you got to be kidding. The treaty is a constitutional compact between two sovereign nations. That's the public debate that we should be having, not about a series of principles that Māori didn't ask for, and certainly not the unprincipled principles in this current bill. So I'm going to leave it there, and the rest of my submission can be taken as read. Thank you. Happy to answer any questions.
Sure, Maui, thank you very much. We've got 3.5 minutes remaining, so I'll take questions first from Willie Jackson, then Todd.
Kia ora, Maui, and thank you for your submission. Thank you for your mahi for your people and our people. Can I ask you a view on the partnership debate? Did the judges make the right decision?
Well, you know, what Māori were signing up to was that they would have authority over themselves and their own people, and that the English would have authority over their people. Māori were the majority population back then, and the treaty was signed because of the ragtag bunch who were running riot in Kororareka at the time. That's why the treaty was signed, and the British were worried about the incursion that the French were making. So yes, I think there was a partnership envisaged under that founding constitutional compact.
Thanks, Maui. We'll go to Todd Stevenson.
Thanks, and thank you for your submission today. So just so I'm not sure I understand this correctly, is it your submission that today New Zealand should be governed by two separate sovereign governments?
Look, what I'm saying is that as Justice Lord Cook said, a nation can't cast itself adrift from its own foundations. Our foundations were founded on Te Treaty of Waitangi between two sovereign nations. Now, the fact that hasn't been honoured is not the fault of Māori who signed that treaty. And that's the debate we should be having, not about some principles that have evolved over the last 50 years. It's about the constitutional basis of the Treaty of Waitangi. And what might emerge out of that? Let's have the debate.
Thanks, Maui. Probably final question from Tampa Paul.
Kia ora, Maui. In your oral submission just now, you mentioned that this bill is not unique in that a former leader of the ACT Party tried to do this very thing 20 years ago. Could you talk a bit about what happened there and what inevitably led to it failing?
Look, I don't have all the details. I do know that Rodney Hyde promoted that bill. It got to Parliament and it was rejected. And so, you know, this fiction that, you know, we need to have the debate, it happened 20 years ago and it was thrown out. But, you know, David is promoting himself as the white knight on a charger that's going to put the, you know, the uppity natives in their place. No, that's not going to happen. This debate happened 20 years ago. Let's have a proper debate. Let's have an informed debate, not something that's driven by a political agenda. That's what I'm saying. And I suggest that actually David go and read all of these tribunal reports. There's hundreds of them. And it's not the fault of Māori the debate's not happening, because no one actually takes any notice of what's in those reports or even bothers turning up to the Waitangi Tribunal hearings. I've attended many of those. The media's never there. It's been happening for 50 years right under our own nose. The Crown needs to take responsibility for that as well. Me at all.
Kia ora, Maui. Look, thank you. Well timed. Thanks for coming to us from the Chathams. Really appreciate you being with us. Members, we're going to move on now to submission from Horiana Irwin Easthope, who's with us at the table. Kia ora, Horiana. Welcome to the committee. I've got you, of course, for 10 minutes this morning, so I'll invite you to begin your presentation.
Tēnā koutou, no te tai rāwhiti tēnei, ko Ngāti Porou rākai Pāka me Ngāti Kahungunu ōku iwi, he māma ahau, he wahine Māori, roi anō hoki ahau, ko Horiana Irwin Easthope tōku ingoa. I'll take my submission as read in opposition, but I want to make 2 points orally to the Select Committee this morning. The first is a reflection that I took from Dame Iritana Tawhiwhirangi's tangi that I had the privilege of attending last week in Gisborne and in Tikitiki, the mother of our nation, the mother of the Kohanga Reo movement, who sadly recently passed away. And when I was reflecting on what I could add to what I would say the submissions in opposition have clearly articulated, I reflected on the koho of Bishop Don Tamihere that he gave one night at the karakia for Dame Iritana. And I'm only going to take one thread of that kōrero, so I'm certainly not going to do justice to the richness that was contained in that koho. But the thread that I want to draw on is Bishop's kōrero about the current context globally and domestically, and having the clarity and courage to be able to identify and call out when something is quite frankly absurd. And so the first point that I want to make to the Select Committee this morning is that this bill is an absurdity. It is a legal absurdity in that whilst proclaiming in the very text of the bill itself to not be amending the Treaty of Waitangi, that is exactly what it is attempting to do. It is absurd, in my opinion, that we are taking the time away from critical issues that this nation needs to address to sit here and take time to entertain what I say is a colonial fictional monologue, whilst there are other things that we could be doing to positively contribute to this nation's foundation. I also say that it is absurd that we are spending the money that we are spending on this process, but I say so with humility and respect for your roles in sitting here and listening to the submissions that are being presented to you by New Zealanders on this bill, the large proportion of those submissions in opposition. And so that is the first submission I wish to make to the committee today. as a lawyer, as a mother, as a New Zealander, is that this bill is absurd. The second point I wish to make orally is a submission to my son. So I'm going to slightly change tact. To my son, hi, my darling. Last night we were reflecting on the process that our whānau went through in writing our submissions. That involved going down to Māori land in Otaki, submitting in wānanga with other New Zealanders, Māori, non-Māori, and engaging in debate about what this bill was seeking to do. Respectful conversations to understand one another's perspectives. After that debate, my son sat at his iPad and said, I know what I want to write. And I said, do you want to write it in English or do you want to write it in Māori? And he said, I want to write it in Māori. And so what my son wrote in Māori was, this bill does not reflect the treaty or any of its proclaimed principles. This bill is dangerous in that he thinks it will have, and I agree with him, a negative effect on our relationships with one another as New Zealanders. And finally, he asked the Select Committee to abandon this process at this point in time, acknowledging, he asked me, why have we let it get to this point? And I couldn't quite answer him. That took my son about 7 minutes to write his submission. He then went alongside my beautiful Samoan husband, who also made a submission in opposition, and my mother, who made a submission in about 9 minutes, to get a sausage and bread outside and enjoy the company of his fellow Otaki residents. My son then, we laughed last night as we were reflecting on the fact that 6 hours later, when he came to say goodnight to me in my office, I was still writing my submission. In hindsight, my darling, your approach was the better one. But what I'd like to say to my son in this moment is, please retain hope. Retain hope that actually the conversation and the blip that I believe this is in our history will pass, and that one silver lining that may come out of this situation is that we reflect as a New Zealanders and as a nation on who we want to be moving forward, and the beautiful place that Te Tiriti o Waitangi could play in that future with all of us. That will require us to honestly engage in our history, to honestly engage in the past that we have done, to lean into that, to not be afraid of it. Unfortunately, to take Mr. Batchelor's words, to not be intellectually lazy like my submission is, he is being in his submission, and to simply identify where we've been, where we want to be, and how we want to move forward. And that, to me, is the promise of work like Mātiki Mai, the likes of Papa Moana Jackson, Professor Margaret Mutu, Veronica Tawhai, and others. That is the promise of my tupuna when he signed Te Tiriti o Waitangi in Whakawhitira, the centre of our universe just down the road from Tikitiki. And that is the promise, my son, that I hope you will hold on to use your skills that you are gaining i te reo Māori for the future of our nation. That is all I wanted to say orally to you this morning. Thank you for your time, Mr. Chair and members of the committee.
Kia ora, Horiana. Thank you for your submission. I think your son should run workshops up and down the country, because then we wouldn't have a productivity problem.
Yeah, I agree.
So, that's fantastic. Look, I'll take some questions first from Tamitha Paul and then Tākata Ferris.
Kia ora, Horiana. Your first point was that this bill is an absurdity. Don't you think that's the point though? And I guess the question then is, if that's what's popular in politics, then how can we make sure that we actually make good laws that don't get overtaken by these kinds of spectacles, these absurd spectacles that politicians continue to make?
Excellent question. And if I can go back to my son, when we were talking last night, after we had concluded our discussion about where I might take this and reflecting on Bishop Tamihire's words around absurdities, he said, why are you going? And unfortunately, I think where we are at as a nation, and certainly in this specific example here, is that in my view and with my training, I didn't think I really had a choice. And so, yes, we are participating in what I would call a distraction. But in my view, some of us need to, in order for us to keep our eye on Hawaii and allow others to move much more quickly than I think some of us are to that place. And so really, I completely agree with the sentiment that, are we giving airtime to something that doesn't deserve it, if I can paraphrase perhaps part of your kōrero. And what I would say to that is, unfortunately, at this point, I don't think all of us have a choice.
Sure, thank you. Taka te Bruce.
Pai ori ana, tēnā koe, uru
Tēnā.
tei koto tama. I'll sort of just cut to the heart of the issue. And the heart of the issue is that not enough people understand the history. And in this house, my colleagues on that side of the house don't understand the history. Now, the idiotic thing about that is that the government sanctioned and agreed account of the history is just across the road in archives. And the great thing about that is that school children are just filing through there day in, day out. But here in this house, we've still got a knowledge gap that lets this sort of thing continue. So you've obviously put a lot of time into that mahi and doing the work that's helped to close that gap, that knowledge gap. But it's obviously not working because people just keep ripping it open. So what do you think, like practically, how do you think we fix this? The closing the knowledge gap around the history, the place of the treaty, all of those things.
I think one way to do it, and I acknowledge that it, if I take your comment that it hasn't quite worked, I think it will require a little bit more time. And why I have ended my written submission and my oral presentation to the committee this morning with words of hope is because I am committed to remaining hopeful that in the processes that are being undertaken in our kura kaupapa, our kura iwi, our kura auraki, around ensuring that our children understand our history, its richness, and all it brings with all its difficulties, I have a genuine belief that it will be different tomorrow. Maybe not literally tomorrow, but certainly sooner than it has been. And I will reflect on the words of my great-grandmother when my mother went to her and said, "Can I name this baby Horiana?" She had not allowed the name to be given to any of her other mokopuna because she was racially ridiculed for the name. My mother said to her, "There is another day coming." That day has come. I do not personally receive racial attacks on the daily for my name. And I believe that that is an example of, albeit small steps towards a nation that is less racially divided.
Kia ora, Horiana. Thank you. That's the time we have this morning. I want to extend the committee's gratitude for you being with us in person and submitting today.
Thank you, Chair. Thank you, members of the committee.
We're going to take our submission from LGNZ, Local Government New Zealand now, and joining us online is Yayan Cranwell and Tony Boynton, who are co-chairs. Kia ora, Yayan. Do you want to wait for Tony or do you want to crack straight into it?
Here's Tony.
There's Tony there. All right, kia ora kōrua. We have you for 10 minutes this morning. I'll hand over to you to begin your presentation.
Tēnā koutou katoa. Kia koe e hemi, te he mana o te committee, te minata o te waipaunamu, tēnā koe. Tēnā koe e tākuta, kia koe Willie Hoki, tēnā koe. Nei te mihi, ka memo o te committee nei, nei anō te mihi kauatu kia koutou katoa. Kia ora koutou, my name is Yayan Cranwell and I am an Environment Canterbury councillor. And representing with me today is Tony Boynton, a Māori Ward councillor from Whakatane District Council. We are the co-chairs of Te Maruata and on the National Council of Local Government New Zealand. Today we are speaking on behalf of Te Maruata, Local Government New Zealand's network of Māori elected members and local government sector. Local Government New Zealand is the membership body that supports, connects and advocates for elected members across the country. Te Maruata has a large membership across Aotearoa from Muri Whenua ki Muri Huku, who represent a diverse range of backgrounds, skills, expertise and knowledge. We promote increased representation and participation by Māori in local government. We provide support for councils in building strong relationships with iwi, hapu and Māori groups. Te Maruata has a distinct responsibility to uphold te riti o Waitangi, to support its members and consequently to uphold the integrity and mana of iwi council relationships. Our written submission on this bill covered why te riti o Wai matters to councils, political, legal, financial implications and constitutional concerns. We support Local Government New Zealand's submission, and we would like to emphasise the following points. Councils have responsibilities delegated by the Crown, and they are obligated to uphold Te Tiriti o Waitangi. Fundamentally, changing the principles will significantly affect councils' roles in honouring Te Tiriti and affecting partnerships that help to ensure equity and positive outcomes for all communities in Aotearoa. Te Tiriti o Waitangi underpins the strong and enduring relationships many councils have fostered with iwi over several decades. Now I'll hand over to Tony.
Kia ora koutou. Conversations about the bill are testing relationships between council and iwi. The bill and select committee process in of itself has undermined and will continue to undermine partnerships with iwi and cause great harm to iwi and all communities across Aotearoa. Introducing new and incorrect definitions of treaty principles through this bill will also undermine the foundation upon which council and Māori partnerships are built. These redefined principles will unsettle established jurisprudence and lead to legal uncertainty and potentially a surge in legal challenges. The likely result will be increased litigation costs as councils, and others will grapple with interpreting and applying the new principles. This would place disproportionate financial burden on councils. The bill's new and untested principles would necessitate costly amendments to existing plans, policies and procedures that enable our councils to deliver on their functions and duties. This would require significant administrative, legal and compliance expenditure, diverting much needed resource from our core council business and increasing the costs on our whānau, our ratepayers. For example, Whakatane District Council, in partnership with 3 iwi, have developed a waste management plan and system that benefits the whole community of Matata. This also meets the urgent health needs that are being suffered by the community while also meeting cultural and environmental standards. If this bill were to pass, it would definitely provide uncertainty in the relationship, jeopardising the project, the funding associated with it, and also the potential for litigation, not only from iwi, but the wider community who need to have their wastewater system urgently established and resolved. At Whakatane District Council, Māori wards were established as a mechanism to uphold Te Tiriti, to enhance the relationship with the 8 iwi within the Whakatane Rohe. Prior to the establishment of Māori wards, our council spent hundreds of thousands in court in litigation, from iwi taking them to court regarding decisions that were made without them. Since the introduction of Māori wards, there has been no litigation from iwi. This bill, along with Māori wards legislation to remove Māori wards, would see a return to increased expenditure and litigation and added costs that ratepayers and our councils cannot deal with. Kia ora, I'll hand over to Ian.
Kia ora koutou. Yeah, we agree with the findings of the Waitangi Tribunal and the concerns of the King's Council outlined in their letter to the Prime Minister and Attorney General. Everywhere Māori interests are relevant to a statutory regime, for example, in resource management, Māori would have no rights and their interests would receive no consideration other than as members of the public, just like another stakeholder, like federated farmers, unless their rights were recognised in legislation or in an agreement. And then Tony will conclude.
In conclusion, many councils across the motu are committed to their relationships with Māori, which sits firmly upon the foundation of Te Tiriti o Waitangi. Te Te Tiriti is the bedrock of mahi of our Māori elected members, including their connection and commitment back to their own whānau, their whakapapa, their history and their rohe. The enactment of this bill would not only create legal and financial uncertainty, but it would also undermine the hard-earned relationships and partnerships between iwi and council that have been carefully built over decades, and it would definitely be to the detriment of our wider community. We agree that the enactment of this bill would be the worst breach of Te Tiriti o Waitangi in our history. The bill directly undermines and disrespects Māori rights and values that have been embedded in core functions of many councils across Aotearoa. Te Maroata opposes this bill in all its entirety, and we strongly recommend that it be abandoned. Kia ora.
Thank you both. We've got a couple of minutes left. We've got questions from Duncan Webb, Todd Stevenson, Tampa Paul.
Kia ora, thank you for that submission and thanks for the work that you do in local government. My question relates to that work. It's really asking, how does the role and functions that you discharge in local government reflect the principle of tino rangatiratanga, and how does that tie in with the discussion around partnership that we've just had? Can you discuss that?
Yeah.
Kia ora, Duncan, tēnā koe. I suppose an example of, one example for us, Environment Canterbury, we have two Ngāi Tahu councillors on there, through the House there, legislated through Rino Tirakatani and the work of the Māori Party, Labour and also the Greens. It's a sign of the Environment Canterbury Council working with the 10 Papatipu Runanga here in Canterbury, and then listening to the 10 Papatipu talking about tino rangatiratanga. They wanted to see a face on council. They just didn't want to be in the committees on the second level. They wanted to actually be on the table and show their rangatiratanga. But it was only the start. So the two members, myself and Tūtaki Haunuku, who's ex-member of Parliament on Environment Canterbury, representing the rangatiratanga of Ngāi Tahu on the council table. But we're all there for Canterbury. The 16 of us are there for represent Canterbury. But that's only the start. The 10 Papatipu Runanga want to see more representation and showing partnership, co-governance on Environment Canterbury. Kia ora.
Thanks, yeah. Probably one question from Todd.
So thank you, and thank you for your submission. So do you think the treaty today guarantees different governance rights based on ancestry?
The treaty today, I think that the work that's been done over the last 50 years in terms of ensuring that the mana of Te Tiriti is upheld has only gone through a process in which we aren't in control of. So what we ended up receiving and what we've made the best out of is, in essence, what we are working hard today to retain. There could be far more things done to be able to uphold Te Tiriti.
Thank you. Thank you both for joining us this morning, providing your submission. The committee does appreciate it. We'll move on now to our next submission this morning from Andrew Judd. Andrew's with us online now. So Andrew, good morning. Thanks for being with us. We've got you for 10 minutes this morning. I'll hand over to you to begin your presentation.
Good morning, and thank you for the opportunity to submit today. Just by way of background, my name is Andrew Judd. I was 9 years on New Plymouth Council, one term as New Plymouth Mayor. In that time, I came to realise my lack of knowledge of New Zealand's past, which bored into my ignorance, and ultimately I am now what I term a recovering racist, because the journey I've observed as Mayor and as a Pākehā New Zealander highlighted to me the challenge that we have, more so now as we see through these treaty principles bill. This bill is highlighting the journey that I discovered as a Pākehā. The questions that I asked myself, before I could even get to principles, what does it mean to be a New Zealander? What does it mean to be a Te Tiriti partner? What did I understand about our colonial past, the actions of colonial governments of yesterday and today, in fact, Māori wards, treaty principle bills, these other bills that we see coming forward. And the solution that I landed on is Pākehā, is we don't understand our past. Mr. Batchelor this morning, I could sense it as a recovering racist. He triggered his dog whistling, just as Mr. Seymour does. It takes me straight back to that ignorant attitude that I was fundamentally raised to hold by my country. It's abhorrent that in this day and age, we haven't moved on from anywhere. Cook mailies will have arrived yesterday. This is so, so divisive and sad to observe. Like you, I was elected to represent the community, the country in your case. With that comes such a privileged and respectful position to do what's right by all of us, to uphold truthfulness and honesty and transparency for the benefit of all of us, not just the majority. This treaty principle bill should be thrown out like any other bill that disregards Te Tiriti. Action should be put in place to educate us as New Zealanders about every place before we can even think of getting to a question like principles, which of course don't even exist under Te Tiriti. Mr. Batchelor talked about the comment, once it was signed, it was the seeding of a democracy. Well, that seeding took place all right, and it's become a Eurocentric system, a system designed by Europeans from Britain for British. That's not us. We live in Aotearoa. There was another dog whistle question I often hear. Am I proposing two systems, two forms of governance? What I'm proposing is what I term a reboot, a February 7th, if you like, where we tear down this structure and rebuild it for something that works for us, something that puts Te Tiriti at the forefront, a system that enables self-determination for Māori. That doesn't scare me, not anymore. There's nothing to be scared of, that conversation. Mr. Seymour says, where anywhere else in the world has this system worked where you have two people signing into a governance? We're the example. We lead the world. We show the world how it's done. We should be proud to do that. I just call to you as our leaders to change this narrative, to find a way to bring us together. We are so polarized. What must our children be thinking? And I'm through this committee, speak to the next generation to do what my generation and that before me has not done, refused to do. And that is to keep a hold of Pākehā control over Māori. Until we change that, the pain will remain. So that's why in my submission, it's not the ultimate, the Waitangi Tribunal, but it's worked for 50 years. And it's way better than politicians trying to change the relationship. It's far deeper and far more important through treaty principle bills. Because why? In the 11 years since I was the Mayor of New Plymouth, I've spent hundreds of speeches around New Zealand talking about not only Māori wards, but what it means to be Pākehā. And the questions that I mostly get, and I've done hundreds, comes from where I came from. In the main, we as non-Māori have no idea of our past. Nothing. And yet here we are talking about changing constitutional relationships. I implore this committee to reject it in its form, but to signal that we need to have a conversation, of course, but one that reflects Te Tiriti. Kia ora.
Good, Andrew. Thank you. We'll go to questions. Tim Paul, then Todd Stevenson.
Kia ora, Andrew. Thank you for your submission. I think your stance or your life and your work recovering from that racism is well known. So I want to touch on a different issue. The author of this bill claims, when asked why, a reason for this bill, an example that he gives is that Māori get special privileges. And when he's asked for an example on that, he often always says it's the RMA. You've been a mayor and you've created district plans. You've, been in charge of a place that grants resource consent. Can you speak to us about if there is any truth to Māori having special rights and special privileges within our resource management system?
Well, first of all, Māori have inherent Indigenous rights that were pre-existing rights. That no matter what we want to think as Pākehā or non-Māori can never be changed. That's a given. And from that, and through the RMA as it existed in my time as mayor, thank goodness. Because to balance it up was for people who wanted to remove those barriers, to basically destroy our environment. I mean, we're about to get potentially mining off the coast of Taranaki. And if it wasn't for iwi and Māori protecting it for the next generations, we wouldn't be the clean green nation that we pretend to be overseas. And so a lived example through Mia, is every time you'd get a recommendation from officers, for example, at the back of the report would be a tick box. Does it meet the long-term plan requirements, the annual plan, the budgets, and has it consulted with iwi? Often that box was ticked. But when the question was asked, who did you speak to? Oh, no one. We wrote a letter, didn't hear back. So even though that was in place, that still wasn't enough. So it can't be changed. I know there's something coming behind this. That's horrendous.
Kia ora.
Thanks, Andrew.
Thanks, Andrew. Thanks for your submission. Just actually on your submission, you mentioned actually in your oral submission too, you wanted to have the Waitangi Tribunal mandated with greater legislative powers. Could you outline what those would be and how that would operate?
So that's a conversation from the level of your governance to work through in partnership with iwi, hapu and the Māori, of course. But fundamentally, like a court, we have a founding document, Te Tiriti o Waitangi, which I now realise, of course, as a recovering race, I now realise it's our founding document, and that should be precedent over all legislation. So there must be greater weighting given to the tribunal through legislation that either goes against Te Tiriti or against the principles that exist now with the treaty. And the Waitangi Tribunal would be independent. They are appointed and signed through by the Governor-General. So as mentioned earlier, I think we have a non-elected head of state. So it's not like that we don't have systems that work through these challenges. And these types of bills that we see coming forward would be stopped.
So it could strike down legislation, is that what you're saying?
Absolutely.
Thank you.
Otherwise, you see, the narrative pushback to that is as Pākehā, we fear potentially that we might think Māori might do to us what we do to Māori. And that is, of course, to dominate, control, and have it our way only. When Māori that I talked to and met through all of my time as mayor, and to this day have never come with that approach. It has always been about caring and working together and honouring Te Tiriti.
Question from Willie Jackson, then Tākata Pierce.
Kia ora, Andrew. What's your observation at ground level, your former mayor? What's your observation in terms of particularly a local Pākehā in terms of this bill? Is there support or is there outrage? What are you picking up out there, Andrew?
So in 2013, when I first took Māori wards to the council in New Plymouth, all councils, the mayors at the time, took me out to sort of browbeat me in a cup of tea, and the place went off. And of course, there was a referendum and it was rejected. Since Labor changed the legislation, all 4 councils now have established Māori ward seats. People come to me to celebrate and acknowledge how great that is, how it's been great for the province working well together in terms of this bill. Pākehā that I now speak to that once sort of chastised me are horrified. They find this very divisive and don't understand how it's got to the point that it's got to. And we're trying to work together. Ngā Mutu New Plymouth, we're a point in case of, we've got Te Matatini that's coming forward. The Maong has just been given official name status. So these are great steps forward. Why we would take such a renegade direction is beyond the people I talk to.
Andrew, probably find one from Tākata Pierce.
Oh, kia ora, Andrew. Just quickly, hey, maybe you can just talk to us about your aspirations for Te Tiriti in the future.
Oh, look, I call it reboot February 7th, meaning the day after February 6th. Let's get back around the table and start as it was meant to be, and that is in partnership together. Let's have a system that empowers that. Let's have a system that encourages tangata whenua to truly have their own destiny and control of their cultural ways that work together. Let's show the world that little old New Zealand down here is ahead of the game. We can be more than a two-state solution. We can actually be treaty partners.
Kia ora.
Andrew, thank you, folks. Thank you for your time this morning, Andrew. We appreciate you being with the committee.
Good.
Going to go now to a submission from Ngāti Hokopu Hapu. It's early morning. Ngāti Hokopu Hapu of Ngāti Awa. Kia ora, kōrua. Thank you for being with us this morning. We have you for 10 minutes before the committee, so I'll hand over to you to present your submission.
Kia ora koutou. Just want to welcome, thank you for the opportunity to come before you, the Justice Select Committee. Kia rātou nei kua kōrero hia. Me te whānau e mātakitaki mai ana. Tēnā koutou, tēnā koe hoki rā ki tēnei pire I mui e tātou. So, kia ora everyone, my name is Bradford Hami. I am happy to speak today on behalf of our hapu of Ngāti Hokopu and Ngāti Whare Pāia at Te Whare o Toroa and Hokowhitu Marae in Whakatane. I sit as the chairman of the trustees of Te Whare o Toroa today at Wairaka Marae. And we are part of many hapu within the Ngāti Awa and Matatua region from Whakatane. I'm just sitting here with my daughter Zio as a tautoko for me today. So while the hapu, we're happy to enter into this debate and this conversation concerning the principles of the Treaty of Waitangi and the bill, we strongly oppose this Treaty Principles Bill, and we believe it should be abandoned immediately. We also do not believe this kaupapa should go into a public referendum. I'd like to expand on maybe a few points out of our submission and elaborate on a number of themes. We, as a hapu, we do support the Waitangi Tribunal's findings that this bill would contribute to the dismantling of the constitutional status of Te Tiriti o Waitangi, the Treaty of Waitangi. And maybe just a few points to elaborate on this. I actually go back to the preamble of the treaty, actually, which speaks a number of important things I think are important. And that is of the protection of the rangatira and their hapu, their just rights and their proprietary rights that should lead to or might lead to these terms, rongo and atanoho. That means to peace and civil society. And I believe this bill actually does not reflect what the preamble actually speaks to. The bill, we believe, does not reflect the Treaty of Waitangi, and we think it ignores 40 years of jurisprudence in relation to the current standing principles that we also believe are the re-articulations of the original clauses of the Treaty of Waitangi. So this bill, we believe, will limit the Treaty of Waitangi obligations of the Crown to protect hapu, our proprietary rights, and our kaitiakitanga to te taiao. It was a big issue amongst our young people and as spoken of in the preamble and also in Article 2 of the Tiriti o Waitangi. We also stated in our document, in our statement, that we believe the bill will marginalise our unique hapu voice within the Bay of Plenty region. Article 1 of this bill seeks to affirm full power to the government, but under the treaty, the power of governance to allow the formation of government and also the enforcement of law is pretty much based on the obligations to the other articles of the treaty. We also believe in expanding on that tino rangatira tanga of the rangatira who signed the treaty and their respective hapu. It was something that is pre-existent. It's derived from the mana of whakapapa and ancestors and their sovereignty into their own tribal states. But it is also guaranteed under Article 2 of Te Tiriti o Waitangi. So if this bill was to come to fruition, the trickle-down effect of that would see the full power of governance erode the principle of partnership and will silence our voice in already existing joint agreements and managements agreements with local civil bodies. So we are concerned about that. We stated in our submission that this bill will also, we believe it will replace collective hapu rights for equal rights of the majority, that the voice of the majority actually would overreach into the rights of Hapu. The equal rights of New Zealanders, we believe, are already affirmed and also guaranteed in the New Zealand Bill of Rights of 1990. We believe the collective Hapu rights should not be up for debate or for discussion in a public referendum. Additional points on this I'd like to make. I always felt this was similar in some ways to the way that customary land tenure was individualized by the native land court system of the 1860s, which took a number of years right up into the 1910s, 1920s. And in some ways, we are imposing another set of laws upon into this situation to bring the collective voice of the Hapu into individual majority voices. I'd like to say that Article 2 of the Principles Bill, while it gives homage to Hapu and iwi within the context of the treaty settlement process, which has really only amounted in some ways to between 1% to 3% of full compensation. It kind of categorizes Māori rights within the context of the breaches of the treaty, but not within the context of the original treaty and its obligations and responsibilities. In expanding on that, I think that the breach of the treaties needs restoration, and restoration means coming back to the original state of what the treaty was, which I see as a covenant, really. Henry Williams said it was a sacred compact. Many of the rangatira saw the treaty not just as a contract but as a kawenata tapu. It has a lot more responsibility to it than just being a document like a contract. It has a lot more responsibility being, if we see it in the light of a kawenata. If the Māori rights were delegated solely within the sphere of the breaches of the Treaty of Waitangi, then our voice or our voices in already existing joint agreements and managements with local government agencies and civil bodies which sit outside of the treaty settlement processes, they will probably be very much impacted. And this, we believe, will therefore undermine our intergenerational commitments to the next generation of Ngāti Hokopu and Ngāti Awa. So in saying that, I'd just like to present that to you and leave a bit of time for questions. Thank you.
Kia ora, Bradford. Thank you. And thanks, Ziel, for being here with us as well. Members, any questions for Bradford? We've got one from Todd Stevenson.
Hi, thank you. And thank you for your submission. We appreciate you being here. I just want to understand from your perspective, so Article 3 of the treaty, what rights do you think that confers today?
I think that confers citizen rights within what the treaty says as British citizens, whatever that means. But it also is and I don't think that's really kind of played out fully at the moment in the past. But I think we have to read all of these in light of the other articles rather than separating them out into separate articles. So we all have a right of citizenship, but in light of the other articles as well.
Thank you.
Thanks, Bradford. It's probably the time for this morning. Look, I just want to acknowledge and appreciate you both. Did you want to make a comment, Willie?
Yeah. Can I
Willie
just,
Jackson.
thanks, Brad. Brad, so Māori in terms of preferential rights, what do you say, that extra privileges? That's the line that they're running on this and is driving this, that we have all these preferential rights. What's your comment on that, Brad?
Well, I think a lot of those preferential rights are actually part of what obligations and responsibilities to the treaty are. They're not preferential. They are like an expanding discussion on what it really looks like to actually be maybe in a partnership. So I don't see them as particular prejudices they're part of the obligations of the nation actually to protect the proprietary rights and the just rights of Māoridom.
Thanks, Bradford. Thanks, Willie, and Dio as well. Thank you both for being with us this morning. We appreciate your time and your submission. We now have a submission in person on behalf of the 50 Kings Council, and joining us at the table is Sir Geoffrey Palmer and Karen Faint. Good morning, Karen. Good morning, Sir Geoffrey. Thank you for being with us. We've got you before us for 10 minutes this morning, and you've brought a friend. So if you'd like to introduce your friend as we go, we'll hand over to you.
Tuatahi tēnā koutou e nā rangatira o te whare paramata nei, o tērā tēnā te mihi atu ki nā roia kingi kua tae mai ki te tautoko I te apa nei. My name is Karen Faint and I'm here attending with fellow King's Council Sir Geoffrey Palmer, Sir Hugh Rennie, Mr Peter Mackenzie and Sally Jepp. And we also have other KCs online watching and supporting. So we had a total of 50 KCs who signed up to our submission opposing the Treaty Principles Bill as being contrary to Te Tiriti o Waitangi and also to the settled legal and constitutional arrangements in this country. I want to make 3 points before I hand over to Sir Geoffrey. The first is that the name Treaty Principles Bill is a misnomer. And we say that because in reality, the bill's not about the principles of the treaty at all. It's about fundamentally seeking to rewrite the treaty itself by stripping the important Article 2 guarantees of tino rangatiratanga and property rights that were made to Māori. And we say that Parliament cannot and should not unilaterally and retrospectively rewrite the treaty. As the Court of Appeal put it in the quote that Molly Solomon has already voiced this morning, a nation cannot cast adrift from its own foundations. The treaty stands. My second point is that far from creating certainty, as David Seymour claims, this bill would actually generate considerable confusion and uncertainty. And we say it would upend the progress that has been made by governments of both stripes over the last 50 years towards recognising Te Tiriti as part of the constitutional bedrock of this country and making amends for past breaches. Importantly, this progress has been supported by governments of both stripes, but also by all three branches of government. And we say that Parliament itself has led the way by incorporating the principles of the treaty into dozens of statutes from 1975 onwards. My third point is that in response to the submissions made by fellow KC Gary Judd and some others who have argued that the courts have acted improperly in recognising and endorsing Te Tiriti o Waitangi, we submit to the contrary that it would be Parliament that would be acting improperly and irresponsibly should it enact this bill which so clearly attempts to distort and rewrite what amounts to an international treaty. I heard Gary Judd in his submission say that the courts are wielding the principles of the treaty like a weapon. In response, we say that's irresponsible criticism of the courts, accusing them of judicial activism when in fact they're fulfilling their role of determining the meaning of the law laid down by Parliament, which has incorporated the treaty principles into legislation. And I'd remind you that the Lands case of 1987 emanated from the treaty clause in the SOE Act, of course. Further, we say that there's a high degree of consensus between the branches of government on the status of Te Tiriti. So the Supreme Court in the Trans-Tasman Resources case recently said that the treaty has constitutional significance. That reflects what the Cabinet Manual says, and the eminent jurist Sir Kenneth Keith has written in the Cabinet Manual that Te Tiriti is one of the major sources of the Constitution and that it accords special recognition to Māori rights and interests. So finally, we concluded our letter by saying that introducing a bill without a policy process is the wrong way to go about having an important and sensitive constitutional conversation. And Sir Geoffrey is going to explain that point further.
Thank you, Karen, very much. And greetings to members of the committee. It's lovely to be here in front of a big committee. I want to carry on the stress that Karen just put on paragraph 7 of the written submission. I'll just read it. Whether constitutional reform is required and how that should incorporate Te Tiriti is a long-standing, complex and contentious issue in this country. A constructive and good faith national conversation is appropriate in light of the history. This should be approached with utmost care and respect. Those issues warrant a thorough and considered processes involving public education, engagement, and consultation. Process is everything. I want to stress, looking forward, the importance of the committee considering the fact that process is everything. Because I wish to argue in front of you that the process that led to this bill's introduction was fundamentally flawed compared with the processes that are used for legislation customarily in this House. The Cabinet Manual in paragraph 7.65 says that ministers must confirm that bills comply with certain legal principles or obligations when submitting bids for bills to be included in the legislative program. In particular, ministers must draw attention to any aspects of a bill that have implications for or may be affected by the principles of the Treaty of Waitangi. Now, think about that. The reason that is there is that the treaty is binding on New Zealand not once but twice. It's binding as a matter of international law. It's binding because it was made for New Zealand, and it's binding because we are the successors to the British powers that they used to have, which we now have. So if this were breached, there would be international difficulties with Indigenous rights in a liberal democracy like this, and one ought not to undergo that sort of risk. So orthodox policy processes before the introduction of a bill like this would require, in normal circumstances, in-depth analysis that would precede the taking of decisions. The policy options would be analysed. There would be interdepartmental consultation and discussions, and Maori would be consulted. Now, instead, what we've seen is a bill that has clogged up the House with more than 300,000 submissions, it is said, wasted a tremendous amount of time and money, and it has damaged the collective fabric of the nation. That is what happens, I urge members of Parliament to consider, if proper legislative processes are not adopted. You don't have a policy process that starts with a bill. A policy process ends with the introduction of a bill. And that is the basic flaw which this ill-considered bill has suffered from, and it ought to be cured in the future. We really need to learn from this. This is the final thing I want to say to you.
Geoffrey, we do have some time for questions. Duncan Webb, then Tamara Ball, then Todd.
Kia ora, thank you. I'll be quick. And I thank you for your discussion, which from it I take it's widely recognised that the Treaty of Waitangi is part of the constitutional law of New Zealand. The bill itself is premised on the approach that Parliament can do whatever it wants. Can you talk about whether it's legitimate for Parliament to do this? And is Parliament itself bound by the commitments set out in the treaty?
I think that the important thing to stress here is the dangers of majority tyranny over a minority. And that is a principle that in democratic countries one has to respect and be careful about. And I do think that the discussions that we would hope would take place would try and produce calm over the whole area of the treaty and find a way forward for addressing the issues so they don't remain the subject of enormous and useless contention out of which nothing is resolved. And that is what worries me about this whole process, because it is not going to achieve anything, but it is going to damage us. And we don't need that.
Thank you, Sir Jeffrey. Sorry, Tim, I've been told that's the time I've got this morning. Can I just
Point of order,
acknowledge
Chair.
your...
Point of order. I seek leave for these minutes to be given another 5 minutes because there were a couple of...
Okay, leave sought. Is there any objection?
Yeah.
There's objection. Thank you for your time this morning. We appreciate you being with us.
No, and
and
you
for
don't like
spending
it,
your
eh?
time.
I want to hear brilliant bits of that out, eh?
It's not that I don't like it, I've just...
All right, no, that room...
You don't want to hear from brilliant people
Willie,
like that, do you?
Willie, if you carry on like that, you'll
Yeah.
have to leave the room as well. Look, we'll just bring the room to order. Thank you for your submission.
Kia ora, kia ora.
Greatly appreciated. And we appreciate the time.
No
this morning.
disrespect.
Yes.
but We've got a process.
Look, I'll just move on to the committee. Some of you might be new to how we're running this process, but submitters have 10 minutes to provide their submissions. We are on a very tight time frame. The more time that members take up eating into that time, the less time we have to hear from the public on this process. And if there is more disorder, I will make rulings and members can go spend their lunchtime somewhere else.
Well, you can't...
We'll now invite Stephen Norrie to make a submission. Stephen, thank you for joining us online. Apologies for the delay in bringing you forward. We have you for 10 minutes this morning. We invite you to present your submission to the committee.
Mr. Chairman, Marina, and thank you very much. I guess what I wanted to start talking about this morning was what motivated me to make this submission on the bill at all. I'm not a member of any political party. I do not belong to any organisation that has a particular axe to grind in this matter at all. I was concerned about the trend over the last 30 or 40 years, more particularly the last 20 years, being taken by our judiciary and our political elites in interpreting what was the so-called treaty principles as they stand at the moment. And in a wider international context, I'm also concerned about what I see happening abroad. There have been some spectacular examples in recent history of social upheaval in democracies where there has been resistance against positions put by the political elites to their populations. And the examples we all know in recent times are Brexit, The Voice in Australia, and most contemporary of all is MAGA in the United States and New Zealand. In a democracy, which has of course been called the tyranny of the majority, it is imperative to include the wider population in any change. For all of that, there was Winston Churchill, if I can paraphrase, who said, democracy is the least worst form of government that we know. And we have successfully made changes to our democracy over my lifetime, and perhaps the most significant of those was the introduction of MMP in the 1990s. And one of the fruits of that, of course, was that it gave Maori a much broader representation in Parliament, which is something that I personally celebrate. The majority of New Zealanders are accepting of social change and will support it if they are consulted properly and brought along in the process. Examples of acceptance of social change in recent history are the Treaty of Waitangi settlements for atonement for the 19th and 20th century breaches of the treaty, and one can debate the adequacy of those. I think personally that they probably are insufficient. There was a fiscal envelope promoted by the then Prime Minister Jim Bolger of $1 billion, which was quickly exceeded. And I think today few Kiwis would argue that there was a justification for the settlements that have been made. Another thing which has been a social change in my lifetime is the emergence of te reo, or should I say the re-emergence of te reo, and its common use today in everyday English. This is a unique taonga both for Maori and non-Maori. We can speak fluently in the world's lingua franca and also have a uniquely Kiwi dialect which distinguishes us from the rest of the English-speaking world. No one can know what Captain Hobson and the Maori chiefs precisely thought they were signing in February 1840. Captain Hobson probably thought Maori was ceding sovereignty to Queen Victoria in exchange for the protection of the British Crown. And I note that the preamble in the English version uses the word ceded. Maori chiefs probably thought they were offering rights of government authority to Queen Victoria in exchange for the same rights of duties and citizens as the people of England. The rights of government authority and what they meant in practice was probably imperfectly understood. It's unlikely that any of the signatories thought they were entering into a partnership. The difference between the English and the Maori versions is problematic and has led to so much social disquiet in recent times. In the absence of a tiebreaker clause, which you would find in contemporary bilingual legal documents, both versions have equal validity. And it appears to me that there's been a recent tendency to denigrate the English version vis-a-vis the Maori version, and I think this is improper. Neither version is superior to the other. Partnership is a modern construct that has emerged in the late 20th century. It has the flaw of creating different rights between Maori and non-Maori. The reaction recently against Three Waters and the Maori Health Authority show the strength of public feeling about different rights. For the long-term and sustainable harmony of our society, it is imperative that we have well-defined treaty principles that recognise the importance of the treaty as our founding constitutional instrument. For long-term social harmony, it is imperative that those principles have the imprimatur of democratic acceptance. This is a matter that cannot be left to political and social elites or an unelected judiciary. This is why the referendum proposed by the bill is so important. The bill may not be perfect, but if it is allowed to become law and the referendum is successful, it should provide a stable constitutional platform on which we can continue to build our nation. Leaving the interpretation of ill-defined treaty principles which lack a broad acceptance to unelected judiciary will sow the seeds of long-term discontent and potential disruption to the social fabric of our nation. My plea is that the parties that comprise our parliament today vote to approve the bill or an amendment of it into law so that the principle of the treaty can be considered by all New Zealanders through the process of a referendum. If the referendum is successful, the principles will have a democratic mandate that should be recognised by the judiciary and future governments. This will provide a stable constitutional platform which will hopefully preserve social harmony in New Zealand for generations to come. Thank you. And any questions?
Thank you, Steve. We've got a time for questions. We'll start with Todd Stevenson.
Thank you. Thank you for your submission, Stephen. I was just interested, obviously you're an immigration advisor. And you're obviously dealing with some immigrant communities. How do you think they view this discussion around the treaty and what rights it may or may not confer?
Yes, it's my privilege on a day-to-day basis to deal with New Zealanders. Obviously, when you think about migrating to another country, you always look at the context of what's happening in the background. All countries have their own debates going on at the moment about constitutional arrangements. To look at the United States at the moment as a case in point. And so I think people look at this and they see it for what it is. It's a nation having a discussion with itself about how it should go forward. And it's doing it in a fairly orderly and well-mannered way. I mean, there's protest and there's strong feelings, but there's still the ability to korero. And I think that my clients, who the New Zealanders, look at that as a positive thing.
Thank you.
Thanks, Steve. Taka Ferris and Willie Jakes.
Hey, kia ora, Steve. Look, one of the troubles with this convo is there's just not enough clarity. I mean, I take your point that you've said that both versions are equal. That's actually not the case. You know, in international treaty law, and treaties sit in international law, not domestic law, there is a convention called Contra Preferentum, and Maui talked about it this morning. And that quite clearly states that if there is disagreement in interpretation between two versions of a treaty, then the version that's written in the receiving group's language takes precedent. So the two versions aren't equal. And this is part of the problem, you know, and given you're in immigration, you know, I'm thinking, well, we've got a lot of new Kiwis coming into the country. What's the quality of their education look like? So that's my question for you. What is the quality of tiriti education, or the shape, the form of it for New Zealanders that come into the country every year?
In my code of conduct, there is an obligation for me to have information on Te Tiriti and to advise if I'm asked. I've been advising clients now for 9 years as an immigration advisor. I've yet to have one client ask. I do have reference books. I do have material that I can refer to, and I'm a autodidact, if you like, in this area. So I have yet to be asked by one of my clients about Te Tiriti.
Thanks, Willie Jackson.
Thank you for your submission, Steve. I'm a little bit confused by it because I can see there's some support for a number of kaupapa Māori, so thank you for that. I just want your view on the tino rangatiratanga, because you accept that the chiefs did not concede in terms of their rangatiratanga. Do you, and you might have heard the King's Council's legal people, Indigenous rights, is that something that you think is appropriate, or do you deny that Māori should have those types of rights?
I do think that there is a need for Indigenous rights, Willie, but that said, there has to be a bringing along of the broader population in the process. What we saw in the last 10 or 15 years in particular was government and the judiciary getting ahead of the wider population.
Thanks, Stephen. That's the time this morning. Thank you for joining us online and providing.
Thank you for your time.
We're going to invite now Dr. Dean Knight to join us at the table. Thank you for joining us from all the way across the road, Dean. It's nice to have you here. We've got you for 10 minutes this morning, so I'll hand over to you to start your presentation.
Kia ora e te committee. Thanks for the opportunity to address you on this important topic. As you know, I'm a Professor of Law at Te Herenga Waka, Victoria University of Wellington, specialising in public and government law. So I come to this discussion from a constitutional perspective, looking especially at the nature of the norms in play and the relative functions of our important state bodies. And in my view, this bill is constitutionally misconceived. The bill is predicated on the principles of the treaty being a thing or a set of norms created by Parliament, and thus, like other things and legal norms, able to be changed or re-legislated at will by Parliament for obedient application by the executive and the courts. And that's the simplified version of Dacian parliamentary sovereignty on which this bill is based, and some others have urged on you. But for me, the particular and special context we're in means I'm not sure that holds true. Here, it's more complicated than that, and I think this bill risks being constitutionally ineffective. For me, rather than being a thing or independent norms created by Parliament, I see references to principles of the treaty more as an interpretive cue. That is, when referring to treaty principles, it's a message from Parliament to the executive and courts, first, that Te Tiriti, the treaty, is implicated, and secondly, signalling the expected style of interpretation. And for that matter, a style of interpretation that generally aligns with our long-standing interpretive traditions here in Aotearoa, New Zealand. Things like text in light of purpose and context, generous and practical and ambulatory readings of instruments, mindful of principles like contra preferendum and so forth. And I fleshed that out, that sort of idea of treaty principles as meaning, I fleshed that out more in written submissions in the context that they were first enacted in 1970s and 80s. But to put it another way, to the extent that treaty principles are a set of norms, they're derivative norms. They're intrinsically connected to the original source instruments, intrinsically tied to Te Tiriti, the treaty, and its essential meaning in law. And in my view, this is where this bill fails. It ignores the fact that in reality, treaty principles are shorthand for the meaning of Te Tiriti in the treaty itself. Treaty principles embody something that has existing meaning, and thus the treaty principles are descriptive in character. But this bill seeks to sever that intrinsic and derivative connection and seeks to fill that descriptive reference with normative content, recasting Te Tiriti in terms of what promoters think it should mean as a constitutional document, regardless of the fact what it actually does mean as a matter of historical and constitutional fact. And in doing so, the catalyst for the bill is an erroneous objection to the work of the courts and tribunal, as if they are legislating content of treaty principles when they're grappling with their application, when actually they're simply undertaking the orthodox interpretive function of elaborating meaning as it exists, meaning of Te Tiriti, the treaty. And very concerningly, this bill seeks to legislate a legal fiction. And others have explained the variance between what Te Tiriti, the treaty, means and what's proposed in terms of principles. And that injects mistruths about Te Tiriti and the treaty into our statute book and is deeply concerning. That doublespeak about Te Tiriti, the treaty, would bring incoherence and uncertainty and inevitably leave it to the courts to try and mop up the mess. And in my written submission, I sketched some of the possible responses to that, but it's hard to know how that might play out. Importantly, Te Tiriti, the treaty, means, importantly, what Te Tiriti, the treaty, means, like other constitutional instruments, is ultimately a legal question that is ultimately answered by our judicial branch of government in accordance with the rule of law and the separation of powers. Put it bluntly, the meaning of Magna Carta isn't worked out by taking a straw poll at the pub on a Friday night. So too with Te Tiriti, the treaty, and the elaboration of its true meaning in law. It's a matter of considered and sophisticated rendering of meaning. And that's not to say that other branches of the public have no role. For example, the legislature might legitimately particularise treaty duties in specific contexts for action by ministers and public servants, sure, but the particularisation is subject to the court saying that's under-inclusive or pointing out it does not reflect the proper meaning of Te Tiriti, the treaty in law. And the public, of course, is a key voice in building our constitution too. But this bill isn't the exercise of the people's, the constituent power needed for a new constitutional settlement, especially where what is being disrupted or cast aside is a foundational treaty between two peoples that predates the genesis of Parliament's institutional form, lawmaking authority, and its constitutional legitimacy. For me, this bill confuses legislating, interpreting, and constitution making, and fudges legislative authority and constituent authority. Overall, the bill is constitutionally misconceived, wrong in principle, and in any event, if it was enacted, I think it is unlikely to be effective too. Kia ora.
Thank you, Dean. We'll take some questions now. We're going to go Duncan, Tamitha, Todd, Takatu.
Dean, I'll be quick. Interesting, you started with Dicey and parliamentary sovereignty and the suggestion that it might not be a useful framework. I guess my question is this. Do you see Parliament itself and the work we're doing here as constrained by the treaty?
I'd come at that question with two dimensions. The first one is the one that I front-footed here, which is the question of whether that Parliament is within the authority of the Parliament to amend Te Tiriti directly. It doesn't actually purport to do that on its terms at the moment, but in effect, that's what it's doing. And I think the argument is that it probably can't do that with legislative, bare legislative authority there. So it's outside the competence of Parliament to do, or put another way, if it was done, it's unlikely to be given effect to an application. The corollary question is, what then does that mean in terms of other work of business of Parliament and that is contrary to Te Tiriti, and is that invalid, or is Te Tiriti a constraint on parliamentary authority as it relates to ordinary business. And there is credible scholarship making that very point. And the committee would do well to reread Dame Sian Elias's article on sovereignty, where she advances that very point. Professor Ruru makes a very similar point as well. You know, there is an argument about, there's a little bit more, I think, work to be done on what that means and how that works and so forth. In the present context, the first proposition is probably the one that I think is most important.
Thank you. Tamitha, then Todd.
Oh, I'm happy for Todd to go
Todd,
before me.
Just a quick question then.
Education within.
Could Parliament codify the articles of the treaty by legislation?
He just answered that.
Yes. It's a question of some nuance, because a good faith particularity of the treaty principles, which is still leaves intact the ability and the authority, the constitutional role of the courts to elaborate the meaning of tutility and to signal to Parliament through declaratory relief or through other means to say that what Parliament has enacted is under-inclusive or is at odds with the treaty. If that was left open, there's a possibility there. But this is not that.
And that's not what I was asking.
Yeah,
That's why
yeah,
I was asking
yeah.
specifically the treaty.
Todd Lowndes. Thanks, Dean. Tamitha Paul.
Oh, okay. I'm going to ask you the same question I asked Horiana. This bill is an absurdity. What can we do to stop bills like this coming through? Because clearly this is an enormous waste of time and is just a big spectacle. So how do we get better laws, far better laws than this one?
Yeah, for me, a lot of this, and I'll be quick on this, is improving our constitutional literacy. And it's a big mission, a big project across all dimensions of our community, our civic life and so forth. And that's that civic literacy, which understands the constitutional arrangements, doesn't talk in mere slogans of parliamentary sovereignty, you know, as if it's an answer to everything. These questions are nuanced and complicated. In schools, we've got to understand our history and so forth, our universities and so forth. We've got great resources. A lot of this stuff has been traversed in the Waitangi Tribunal and scholarship and court decisions as well. We need to bring that into that conversation. So it's a considered conversation and a sophisticated conversation amongst our polity.
Thanks, thank you. Thank you for your time this morning.
Got it.
Thanks.
Thank you.
No, yeah.
We're going to invite our final submission from this morning from Hague. Kevin, thank you for being with us. Assume you've sped at a reasonable speed from the West Coast to be with us today. So good morning. Thank you for being with us. We've got you for 10 minutes. I think you know how this process works. I'll hand over to you for this submission.
Ko te mea tūtahi ka mihi mō ngā mana whenua o tēnei rohi ki Te Atiawa me Ngāti Toa Rangatira hoki tēnā koutou. Ki a koe, James, me ngā mi mō te komiti hoki tēnā koutou. E mihi ana hoki kia ngā tangata kapua ko taua nei tēnei wā. As you say, I've been where you are, sitting on a controversial bill with many submissions, not as many as you're hearing, but hearing the same arguments over and over and reading those same arguments again and again. So I'm going to try and make my comments this morning focused on some things that you could include in your report. You're best placed to really know the enormous waste of time and resource and opportunity that this bill represents. But I want to just briefly mention a second really big cost of this bill, and that's the invitation to racism that the bill represents. And I refer to that in my written submission. Since that written submission, I've seen the submission of Dr. Sanjana Hatutoa, and I really recommend that submission to the committee for its documentation of the racism that has been platformed by the bill. And I suggest to the committee that one of the things that you look at doing in your report is consider some ways that Parliament could respond to that expression of racism, with some definitive statements, for example, but also perhaps some mechanisms towards remedying some of that. The central point of my submission is the logical absurdity at the heart of the bill. And in the time that I've been in the room, several other submitters have referred to that point. I spent a lot of words on it in my submission, but the Honourable Chris Finlayson summarised that point in 2 sentences when he said, Parliament can legislate that the earth is flat. That doesn't make it flat. The treaty is an actual document which has actual principles, and those principles can't be changed by legislation. The bill does 2 main things. It removes the current reference to the actual principles of Te Tiriti, and it replaces those with a set of ideas that David Seymour has basically referred to as, here are some ideas that I came up with as kind of rules for better living, everyone. And I want to talk about those new principles that he suggests. They bear no relationship to the treaty itself, to any kind of common sense understanding of what the principles of the treaty might mean, or indeed to the actual principles that the courts and the Waitangi Tribunal have developed over the past 50 years. And instead, what they do is they haven't just left a gap in the legislation. They haven't replaced the principles of the treaty by removing the words "the principles of." Instead, they substitute in this, what I've described as a cuckoo's egg or a Trojan horse of ideas from the ACT Party ideology. And one of the things I say in my written submission is that has a basic problem in that those ideas are not defined in the proposed bill, and that means that potentially very major and radical changes are being made to dozens of statutes without any proper scrutiny or process, unless it's this process. And I don't know how much time your committee has spent looking at all of those amendments to statute that would result from this committee, but I'm going to bet you that it's not much. And I'm going to bet you too that when the public made their submissions, they weren't particularly thinking about how does this affect the Conservation Act, for example. I started by, and so I'm urging that your report doesn't just gloss over that point. It's actually a fundamental and important constitutional point. I started by talking about the waste of time, resource and opportunity and the platform the bill has provided for racism, but there has been one positive effect of the bill, and that has been the fact that most New Zealanders have actually been galvanised into taking a stand, taking some action, standing up for Te Tiriti, standing up for the kind of nation that we want to build and that we want our kids and our grandkids to be able to live in. That's not just a vibe. You know, I picked up on the vibe because of all of the people that I have helped to make their very first submission on any bill ever. But there's also research that I refer to in my submission that the Human Rights Commission commissioned from Horizon Research from November 2023, which shows that actually by sizable margins, most people believe that Te Tiriti is important. Most people want to see Te Tiriti honoured. Most people believe that we should have a country where everyone understands our history. I don't know whether this has already been tabled to the committee. If not, I'm happy to provide it to the clerks this morning, but this is the follow-up survey by Horizon Research for the Human Rights Commission undertaken in December last year, which showed that, if anything, those margins, that hefty support for honouring Te Tiriti and for teaching our history has, if anything, increased. So, for example, those people who thought that it was important who agreed that harmonious race relations through honouring the treaty and Te Tiriti is important, that increased from 66% in November 2023 to 72% in December last year. So if anything, this bill has catalysed more support for honouring Te Tiriti. Just 18% disagreed. 85% of people think it's important that we should be a country where everyone knows its history. And very clearly that is not yet the case. So there's much progress that we still need to make towards honouring Te Tiriti. It's fundamentally a constitutional document. It sets out that power sharing between rangatiratanga on one hand, kawanatanga on the other. We need to be having a national conversation about that. Government needs to be engaging with iwi and hapu about what that constitutional agreement should mean for our governance arrangements today. And the government needs to be engaging with New Zealanders about that point. And what I recommend to you in my written submission and what I urge on you now is that one of the things that you should incorporate in your report is to urge the government to initiate both those discussions with iwi and hapu, but also a national education program to educate all of our citizens about Te Tiriti and about our history, so that there is a proper basis and platform for those discussions that we need to have.
Kia ora. Kia ora, Kevin. Thank you. Look, unless it's a very short, sharp question, that's probably the time for this morning. So I'll just acknowledge your submission and thank you on behalf of the committee for being with us, in particular in person. It's really good to see you.
Can I just, I don't know, raise points of order? Not sure if that's what it is. I've just gotten a few messages during those hearings that the captions were not working on the Justice Committee live stream, and apologies if this has already been before around the accessibility, but is there a plan to work on that? Because
It has been raised. We can probably discuss it in closed session because I'm not sure whether it's still a matter before the committee. Yeah, we'll talk about it shortly.
can we talk about it when we move into private shortly?
Thanks, folks. That's the end of our hearings for this morning. Public